I'm gonna read this article. 163 US 537 1896 Pressy versus Ferguson, Supreme Court of United States. Argued April 13th, 1896. Decided May 18th, 1896. Error to the Supreme Court of the State of Louisiana. Mr. A.W. Tuggy and Mr. S.F. Phillips for plaintiff. In error, Mr. F.D. McKinney was on Mr. Phillips' brief. Mr. James C. Walker filed a brief for plaintiff in error. Mr. Alexander Porter Mose for defendant in error. Mr. M.J. Cunningham, Attorney General of the State of Louisiana, and Mr. Leonard Adams were on his brief. Mr. Justice Brown, after stating the case, delivered the opinion of the court. This case turns up the opportunity of an act of the General Assembly of the State of Louisiana, passed in 1890, provided for separate railway carriages for the white and colored races. Act 1890, number 111, page 152. The first section of the statute enacts that all railway companies carrying passengers in their coaches in this state shall provide equal but separate accommodations for the white and colored races. By providing 2 or more passenger coaches for each passenger train, or by dividing the passenger coaches by a partition so as to secure separate accommodations, provided that this section shall not be construed to apply to street railroads. Where am I reading? No person or persons shall be admitted to occupy seats in coaches other than the ones assigned to them on account of the race they belong to. By the second section, it was enacted that the officers of such passengers were trained. Such passengers trained shall have power and are hereby required 541 to what? Required to assign each passenger to the coach or compartment used for the race to which such passenger belongs. Any passenger insisting on going into a coach or compartment to which by race he does not belong shall be liable to a fine of $25 or in lieu thereof to imprisonment for a period of no more than 20 days. In the parish prison, and any officer of any railroad insisting on assigning a passenger to a coach or compartment other than the one set aside to the race to which said passenger belongs shall be liable to a fine of $25 or in lieu therefore to imprisonment for a period of not more than 20 days in the parish prison. And should any passenger refuse to occupy the coach or compartment to which he or she is assigned by the officer of such railway, said officer shall have power to refuse to carry such passenger on his train, and for such refusal neither he nor the railway company which he represents shall be liable for damages in any of the courts of this state. The third section provides penalties for the refusal or neglect of the officers, directors, conductors, and employees. What is this? Of railway companies to comply with the act, with a provisor that nothing in this act shall be construed as applying to nurses attending children of the other race. The fourth section is immaterial. The omission filed in the criminal district court charged in a substance that Pressy, being a passenger between two stations within the state of Louisiana, was assigned by officers of the company to the coach used for the race to which he belonged, but he insisted upon going into a coach used by the race to which he did not belong. Neither in the information nor plea was his particular race or color averred. The petition for the writ of prohibition averred that petitioner was 7/8 Caucasian and 1/8 African blood, that the mixture of colored blood was not discernible in him, and that he was entitled to every right, privilege, and immunity secured to citizens of the United States of the white race. And that, upon such theory, he took possession of a vacant seat in a coach where passengers of the white race were accommodated, and was ordered by the conductor to vacate said coach and take a seat in another assigned to persons of the colored race, and having refused to comply with such demand, he was forcibly ejected with the aid of a police officer and imprisoned in the parish jail to answer a charge of having violated the above act. Louisiana. The constitutionality of this act is attacked by the ground that it conflicts both with the 13th Amendment of the Constitution, abolishing slavery, and the 14th Amendment, which prohibit certain restrictive legislation on the part of the state. 1. That it does not conflict with the 13th Amendment, which abolished slavery and involuntary servitude, except as a punishment for crime, is too clear for argument. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as a chattel. What is this? Or at least the control of the labor and the services of one man for the benefit of another, and the absence of a legal right to the disposal of its own person, property, and services. The amendment was said in the slaughterhouse cases. What is this? 16 World 36 to have been intended primarily to abolish slavery, as it had been previously known in this country, and that it equally forbade Mexican peonage. What, I don't know this one. Or the Chinese coolie trade, when they amounted to slavery or involuntary servitude, and that the use of the word servitude was intended to prohibit the use of all forms of involuntary slavery, of whatever class or name. It was intimated, however, in that case, that this amendment was regarded by the statesmen of that day as insufficient to protect the colored race from certain laws which had been enacted in the southern states, imposing upon the colored race onerous disabilities and burdens, and curtailing their rights in the pursuit of life liberty and property to such an extent that their freedom was of little value, and that the 14th Amendment was devised to meet this exigency. What is this? I don't know. So too, in the civil rights cases, 109 U.S. 324 it was said that the act of a mere individual, the owner of an inn, a public conveyance or place of amusement, refusing accommodation to colored people, cannot be justly regarded as imposing any badge of slavery or servitude upon the applicant, but only as involving an ordinary civil injury property cognizable by the laws of the state and presumably subject to redress by those laws until the contrary appears. It would be running the slavery argument into the ground, said Mr. Justice Bradley. Justice Bradley. Boulogne? To make it apply to every act of discrimination which a person may see fit to make so as to the guest he will entertain or as to the people he will take into his coach or cab or car or admit to his concert or theater or deal with in other matters of intercourse or business. A statute which implies merely a legal distinction between the white and colored races. Statute Act. A distinction which is founded in the color of the two races, and which must always exist so long as white men are distinguished from the other race by color, has no tendency to destroy the legal equality of the two races or re-establish a state of involuntary servitude. Indeed, we do not understand that the 13th Amendment is strenuously relied upon by the plaintiff in error in this connection. 2. This is 1. One, 2. By the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are made citizens of the United States and of the state wherein they reside. And the states are forbidden from making or enforcing any law which shall abridge the privileges or immunities of citizens of the United States. or shall deprive any person of life, liberty, or property without due process of law. Due process of law. Or deny to any person with their jurisdiction the equal protection of the laws. The proper construction of this amendment was first called to the attention of this court in the slaughterhouse cases. 16 Ward 36, which involved, however, not a question of race, but one of exclusive privileges. The case did not call for any expression of opinion as to the exact right it was intended to secure to the colored race, but it was said generally that its main purpose was to establish the citizenship of the Negro, to give definitions of citizenship of the United States and of the state, and to protect from the hostile legislation of the state the privileges and immunities of the citizens of the United States as distinguished from those of citizens of the state. The object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law. But in the nature of things, it could have been intended to abolish distinctions based upon color, or to enforce social as distinguished from political equality, or a commingling, what is this? I don't know, of the two races upon terms unsatisfactory to either. Laws permitting and even requiring their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority or inferiority of either race to the other. Inferiority of either race to the other, and have been generally if not universally recognized as within the competency of the state legislatures in the exercise of their police power. The most common instance of this is connected with the establishment of separate schools for white and colored children, which has been held to be valid exercise of the legislative power, even by courts of state where the political rights of the colored race have been longest and most honestly enforced. One of the earliest of these cases is that of Robert versus City of Boston, 5 Cush 198, in which the Supreme Judicial Court of Massachusetts held that the General School Committee of Boston had power to make provision for the instruction of colored children in separate schools established exclusively for them, and to prohibit their attendance upon the other schools. The great principle, said Chief Justice Shaw, page 206, advanced by the learned and eloquent advocate for the plaintiff, Mr. Charles Sumner, is that by the Constitution and the laws of Massachusetts, all persons without a distinction of age or sex, birth or color, origin or condition, are equal before the law. But when this great principle comes to be applied to the actual and various conditions of persons in society, it will not warrant the assertion that men and women are legally clothed with the same civil and political powers, and that children and adults are legally to have the same functions and be subject to the same treatment, but only that the rights of all, as they are settled and regulated by law, are equally entitled to the paternal consideration and protection of the law for their maintenance and security. It was held that the powers of the committee extended to the establishment of separate schools for children of different ages, sexes, and colors, and that they might also establish special schools for poor and neglected children who have become too old to attend the primary school, and yet have not acquired the rudiment of learning. To enable them to enter the ordinary schools. Similar laws have been enacted by Congress under its general power of legislation over the District of Columbia. Rev. What is this? Stat. DC. Sections 281, 282, 283, 330, 310, 319, as well as by the legislatures of many of the states, and have been generally, if not uniformly, sustained by the court. State versus McCain 21, Ohio Cent. 198. Lehue versus Brumel 15 South SW Republic Rep 765. Ward versus Flood 48 California 36. Bartonor versus School Directors 3 Woods 177. People versus Gallagher 93 New York 438. Corey versus Carter 48 Indiana 327. Dawson versus Lee 83 Kentucky 49. Laws forbidding the intermarriage of the two races may be said in a technical sense to interfere with the freedom of contract, and yet have been universally recognized as within the police power of the state. State versus Gibson 36 Indiana 389. The distinction between laws interfering with the political equality of the Negro and those requiring the separation of the two races in schools, theaters, and railway carriages has been frequently drawn by this court. Thus, in Stoddard versus West Virginia, 100 U.S. 303, it was held that a law of West Virginia limiting to white male persons 21 years of age and citizens of the state, the right to sit upon jury was a discrimination which implied a legal inferiority in civil society, which lessened the security of the right of the colored race, and was a step toward reducing them to a condition of servility. Indeed, the right of a colored man that in the selection of jurors to pass upon his life, liberty, and property, there shall be no exclusion of his race, and no discrimination against them. Discrimination against them because of color has been asserted in a number of cases. Virginia versus Lives 100 U.S. 313, Neal versus Delaware 103 U.S. 370, Bush versus Kentucky 107 U.S. 110, Gibson versus Mississippi 162 U.S. 565. So, where the laws of a particular locality of the charter of a particular railway corporation has provided that no person shall be excluded from the cars on account of color, we have held that this meant that persons of color should travel in the same car as white cars. No person shall be excluded from the cars on account of color, and that the enactment was not satisfied by the companies providing cars assigned exclusively to people of color, though they were as good as those which they assigned exclusively to white persons. Railroad Company versus Brown 17 Ward 445. Upon the other hand, where a statute of Louisiana required those engaged in the transportation of passengers among the states to give to all persons traveling with the state upon vessels employed in the business equal rights and privileges in all parts of the vessel, without distinction on account of race or color, and subjected to an action for damages the owner of such a vessel, who excluded colored passengers on account of their color from the cabin set aside by him for the use of white. It was held to be so far as it applied to interstate commerce unconstitutional and void. Hall versus the Cure 95 U.S. 485. The court in this case, however, expressly disclaimed that it had anything whatever to do with the statute as a regulation of internal commerce or affecting anything else than commerce among the states. In the civil rights case 109 U.S. 3, it was held that an act of Congress entitling all persons within the jurisdiction of the United States to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, and made applicable to citizens of every race and color, regardless of any previous condition of servitude, was unconstitutional and void. Upon the ground that the 14th Amendment was prohibitory upon the state only, and the legislation authorized to be adopted by where am I reading? Adopted by where the 14th Amendment does not invest Congress. Adopted by Congress for enforcing it was not direct legislation or matters respecting which the states were prohibited from making or enforcing certain laws or doing certain acts, but was corrective legislation, such as might be necessary or proper for counteracting and redressing the effect of such laws or acts. In delivering the opinion of the court, Mr. Justice Bradley observed that the 14th Amendment does not invest Congress with the power to legislate upon subjects that are within the domain of state legislation, but to provide modes of relief against state legislation or state action of the kind referred to. It does not authorize Congress to create a code of municipal law for legislation of a private right, but to provide modes of redress against the operation of state laws and the action of state officers, executive or judicial, when these are subversive of the fundamental rights specified in the amendment. Positive rights and privileges are undoubtedly secured by the 14th Amendment. But they are secured by way of prohibition against state laws and state proceedings affecting those rights and privileges, and by power given to Congress to legislate for the purpose of carrying such prohibition into effect, and such legislation must necessarily be predicted upon such supposed state laws or state proceedings, and be directed to the correction of their operation and effect. Much nearer, and indeed almost directly in point, is the case of Louisville, New Orleans, and C. Railway versus Mississippi 133 U.S. 587, wherein the railway company was indicted for a violation of statute of Mississippi, enacting that all railroads carrying passengers should provide equal but separate accommodations for the white and colored races. by providing two or more passenger cars for each passenger train, or by dividing the passenger cars by a partition so as to secure separate accommodations. The case was presented in a different aspect from the one under consideration in as much as it was an indictment against the railway company for failing to provide the separate accommodations, but the question considered was the constitutionality of the law. The Supreme Court of Mississippi 662 had held that the statute applied solely to commerce with the state, and that being the construction of the state statute by its highest court was accepted as conclusive. If it be a matter, said the court, page 591, respecting commerce wholly with a state, and not interfering with commerce between the state, then obviously there is no violation of the commerce clause of the federal construction. No question arises under this section as to the power of the state to separate in different compartments interstate passengers, or affect in any manner the privileges and rights of such passengers. All that we can consider is whether the state has the power to require that the railway trains within her limit shall have separate accommodations for the two races. That affecting only commerce within the state is no invasion of the power given to Congress by the Commerce Clause. A like course of reasoning applies to the case under consideration. Since the Supreme Court of Louisiana, in the case of the state X. REL Abbott vs. Hicks, Judge Edward 44 LA ANN 770, held that the statute in question did not apply to interstate passengers, but was confirmed in its application to passengers traveling exclusively within the borders of the state. The case was decided largely upon the authority of Railway CO versus State 66 Mississippi 662 and affirmed by this court in 133 U.S. 500 U.S. Federal Court 587 in the present case. No question of interference with the interstate. Commerce can possibly arise, since the East Louisiana Railway appears to have been purely a local line, with both its termini within the state of Louisiana. Similar statutes for the separation of the two races upon public conveyances were held to be constitutional in Westchester and C. Railway versus Miles 55 Pennsylvania, St. St. 209, Day versus Owen 5 Michigan 520. Chicago vs. and C Railway versus Williams 55, Illinois. 185. Chesapeake and C Railroad versus Wells 85, Tennessee 613. Memphis and C Railroad versus Benson 85, Tennessee 627. The Sioux 22 Fed Rep 843. Logwood versus Memphis and C Railroad 23 Fed Rep 318. McGinn versus Forbes 37 Fed Rep 639. People by King 18. NE, what is this? Rep 245. Huck versus South Park Railway 38 Federal FD. What are the difference FED and US? I don't know. 226. Head versus Georgia Railroad CO 3 limit. Common sense. Common 111. South Carolina 1 LBID 428. What we think the enforced separation of the races as applies to the internal commerce of the state neither abridges the privileges of immunities of the colored man, deprives him of his property without due process of law, nor denies him the equal protection of the laws within the meaning of the 14th Amendment. 14th Amendment, we are not prepared to say that the conductor, in assigning passengers to the coaches according to their race, does not act at his peril, or that the provision of the second section of the Act that denies to the passenger compensation in damages for refusal to receive him into the coach in which the property belongs is a valid exercise of the legislative power. Indeed, we understand it to be conceded by the state's attorney that such part of the act as exempt from liability the railway company and its officials is unconstitutional. The power to assign to a particular coach obviously implies the power to determine to which race the passenger belongs, as well as the power to determine who, under the laws of the particular state, is to be deemed a white and who a colored person. This question, though indicated in the belief of the plaintiff in error, does not properly arise upon the record in this case, since the only issue made is as to the unconstitutionality of the act, so far as it requires the railway to provide separate accommodations and the conductor to assign passengers according to their race. It is claimed by the plaintiff in error that in any mixed community, the reputation of belonging to the dominant race, in this instance, the white race, is property in the same sense that the right of action or of inheritance is property. Conceding this to be so, for the purposes of this case, we are unable to see how this statute deprives him of or in any way affects his right to such property. If he be a white man and assigned to a colored coach, he may have his action for damages against the company for being deprived of his so-called property. Upon the other hand, if he be a colored man and be so assigned, he has been deprived of no property, since he is not lawfully entitled to the reputation of being a white man. In his connection, it is also suggested by the Land Counsel for the plaintiff in error that the same argument that would justify the state legislature in requiring railways to provide separate accommodations for the two races will also authorize them to require separate cars to be provided for people whose hair is of a certain color, or who are aliens, or who belongs to certain nationalities, or to enact laws requiring colored people to walk upon the side of the street, and white people upon the other, or requiring white men's houses to be painted white and colored men's black, or their vehicle or business signs to be of different colors upon the theory that one side of the street is as good as the other, or that a house or vehicle of one color is as good as one of another color. The reply to all this is that every exercise of the police power must be reasonable and extend only to such laws as are enacted in a good faith for the promotion for the public good, and not to the annoyance or oppression of a particular class. Thus, in Yekwo versus Hopkins 118 U.S. 356, it was held by this court that municipal ordinance of the city of San Francisco to regulate the carrying on public laundries within the limit of the municipality violated the provisions of the Constitution of the United States if it conferred upon the municipal authorities arbitrary power at their own will and without regard to discretion in the legal sense of the term, to give or withhold consent as to persons or places without regard to the competency of the persons applying or the propriety of the places selected for the carrying on of the business. It was held to be a covert attempt on the part of the municipality to make an arbitrary and unjust discrimination against the Chinese race, where this was the case of a municipal ordinance. A like principle has been held to apply to acts acts of a state legislature act legislature passed in the exercise of the police power. Railroad Company versus Hussein, 95 US 465, Louisville, Louisville and Nashville, Railroad versus Kentucky 161 US 677, and cases cited on page 700. Target versus Hudson 43 Ohio ST 548. Carpen versus Foster 12 Pick 485. State X Railed Wood versus Baker 38 Wisconsin 75. Monroe versus Collins 17 Ohio ST 665. Horseman versus Rams 41 Pennsylvania ST 396. Oman versus Riley 15 California 48. So far, then, as a conflict with the 14th Amendment is concerned, the case reduces itself to the question whether the Statute of Louisiana is a reasonable regulation. And with respect to this, there must necessarily be a large discretion on the part of the legislature. In determining the question of the reasonableness, it is at liberty to act with reference to the established usages, customs, and traditions of the people, and with a view to the promotion of their comfort and the preservation of the public peace and good order. Gauged by this standard, we cannot say that law which authorizes or even requires the separation of the two races in public conveyances is unreasonable or more obnoxious to the 14th Amendment than the Act of Congress requiring separate schools for colored children in the District of Columbia, the constitutionality of which does not seem to have been questioned, or the corresponding act of state legislatures. Gauged by this standard, I took a mistake in pronunciation. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority, If this be so, it is not be by reason of anything found in the act, but solely because the colored race chooses to put the construction upon it. The argument necessarily assumes that if, as has been more than one the case, and is not unlikely to be so again, the colored race should become the dominant power in the state legislature. and should enact a law in precisely similar terms. It should thereby relegate the white race to an inferior position. We imagine that the white race at least would not acquiesce in this assumption. The argument also assumes that the social prejudices may be overcome by legislature, and that equal right cannot be secured to the Negro expert by an enforced commingling of the two races. We cannot accept this proposition. If the two races are to meet upon terms of social equality, it must be the result of natural affinities, a mutual appreciation of each other's merit, and voluntary consent of individuals, as was said by the Court of Appeals of New York in People vs. Gallagher, 93, New York, 438-448. This end can neither be accomplished nor promoted by laws which conflict with the general sentiment of the community upon whom they are designed to operate. When the government, therefore, has secured to each of its citizens equal right, before the law and equal opportunities for improvement and progress, it has accomplished the end for which it was organized and performed all of the functions respecting social advantages with which it is endowed. Legislation is powerless to eradicate racial instincts or to abolish distinctions based upon physical differences, and the attempt to do so can only result in accentuating the differences of the present situation. If the civil and political rights of both races be equal, one cannot be inferior to the other civilly or politically. If one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane. It is true that the question of the proportion of colored blood necessary to constitute a colored person, as distinguished from a white person, is one upon which there is a difference of opinion in the different states. Some holding that any visible admixture of black blood stamps the person as belonging to the colored race. State vs. Chambers, 5 Jones NC 1, page 11. Others, that it depends upon the preponderance of blood. Gray vs. State 4, Ohio 354. Monroe vs. Collins 17, Ohio St. 665, and still others that the predominance of white blood must only be in the proportion of these. Fourth, People vs. Dean, 14 Michigan, 406. Jones vs. Commonwealth, 80 Virginia, 538. But These are questions to be determined under the laws of each state and are not properly put in issue in this case. Under the allegations of his petition, it may undoubtedly become a question of importance whether, under the laws of Louisiana, the petitioner belongs to the white or colored race. The judgment of the court below is therefore affirmed. Mr. Justice Helen dissenting.